For orders, item 1.
May it please your lordships. Lordships, I beg to, with due apologies, I beg to withdraw the petition, lordships, the IA that I had filed. It was very urgent, so we had filed, but because this is there are 21 parties, lordships, 1 or 2 have withdrawn their consent because this pertains to an individual prayer, lordships. I have written instruction to withdraw the matter.
Okay, matter comes upon for consideration of the IA number 3269 of 2024. On behalf of on behalf of all the petitioners.
Yes, lordships.
On behalf of all the petitioners, however, Learned Counsel on instruction that submitted that she wants to withdraw this IA. Dismiss that withdrawn.
Deeply obliged.
3296.
3296. 3296. Petition dismissed.
Much obliged.
Adjournment request, if any, from item number 1 to 7.
Lordship, I beg to mention item number 5 to 7, your lordship.
Adjourn.
Lordship, can I pay for a date, lordship, in November?
Yes.
26 now. From item number 8 to 18.
May I please, your lordship? With regard to item number 18 of today's, my lord, I'm led by senior counsel, my lord, Vicky Mishra. He is indisposed. I'm praying for 2 weeks accommodation. I've informed the other parties.
My lord, I have instruction from the Advocate General, any day after the 13th of December in this case.
December.
Yes, my lord.
On 16th, we could
Adjourn. Whatever the date.
Okay.
Mr. Mishra is also appearing in this PIL number 3.
I'll be appearing in the document. In the PIL, I'll be appearing.
Yeah, please, your lordship. Lordship, in item number 8, adjournment slip has been circulated.
Adjourn.
Obliged.
May it please, your lordship. I beg to mention item number 16, your lordship.
Adjourn.
Highly obliged.
Any other request?
Lordship, in the series of IAs that we have filed regarding the lottery cases, Lordship, 2 were left out, Lordship. You had submitted yourself, Lordship, 2 were left out. Could this IAs be taken up today, your Lordship? Mention was made yesterday, your Lordship. It was allowed, but 2 were left out, Lordship. It did not come in the process.
Applications you have made?
Total, we had moved 8. 6 came, Lordship. 2 did not come up, Lordship.
6 applications.
Could it be taken up today, your Lordship?
Today itself.
Lordship.
It was lordship, similar prayer, lordship. I have also filed one IA, lordship, in this similar case, lordship. Same what I will cover, lordship, today, lordship. Obliged.
With regard to item number 23 to 27, your lordship, we have this humble prayer, joint prayer for adjournment.
Item number
23 to 27, your lordship. Supplementary list.
Counsel in item 23 is not available. He is informed that there are some difficulty, personal difficulty.
Yeah.
Must have.
Daily list for orders, item 1.
Lordship, we have filed a affidavit this morning only with the inspection report which received yesterday. And we have also incorporated some of the suggestions which they have given. So
what steps essentially you have now?
in fact, some of the suggestions already we have initiated. It was already going on, like preparation of the GIS-based comprehensive drainage master plan and detailed project report. That project work is going on. Then installation of pumping station at strategic locations like Bondajan, Silsako, already it has been done. Then rejuvenation and restoration of water bodies, namely Silsako, Borsola,
These are the proposals and suggestions.
No, these are the proposals he has given, but those works are already in progress.
You have already started
Yes.
those works.
Yes, because Silsako Lordship knows for last 1.5 year, there are huge scale encroachment that we are removed. And the clearing and drainage systems are being done at Silsako. Same is at Borsola and Borsola Bill also.
What you propose about that one gate which they have erected that,
Lordship.
that gate.
Sluice gate, sluice gate.
Sluice gate, yes.
Sluice gate, that is a part of the drainage system. So that work is being done by that Netherlands company.
Whether you are proposing to remove
what
that
we are
gate
doing-
or what,
Regarding diversion of the stormwater from Meghalaya, because he has suggested in a place near Beltola area where it has been closed. So the work is now going on. Diversion of the stormwater from Meghalaya from Khanapara towards Bokhista, towards the Portbill, and augment the seal trap and watershed management of surrounding hills.
sir, our endeavor is only this, that before the next monsoon comes, there must be some
Exactly.
concrete
Uh,
steps.
for that,
My lord, can I
This
make
may
one
not
suggestion,
occur.
my lord? The affidavit which my learned friend has filed, if a copy is served to us,
Yeah, no, it
Ah.
is-
then my lord, we'll give our inputs on that. Okay.
yes,
In that case, lordships can have the matter after the holy holidays on a day, sorry,
Diwali.
Diwali holidays. And we can also respond, my lord, if necessary.
Only
If
one-
it is okay, well, it's okay. If it is necessary, we'll respond.
One further lordship implement may be required because while diverting the water to the national highway, the national highway authorities, they may be made a party because some coordination may be required at later stage.
Will issue necessary direction to them
Lordship,
also.
yes, Lordship.
And my lord, one area of concern is hill cutting, my lord. That should, I think that is entirely within the state administration. Hill cutting, my
Hill
lord, yes.
cutting by the state of Assam or by the? state of-
Even by state of Assam, my lord. Meghalaya is rampant, my lord.
You just
That-
point it out.
Lord.
Yes. My lord may have it following the Diwali holidays, my lord. We'll respond to because
Okay, Mr. Sekia, let me dedicate them and submit that. The progress report pursuant to the order passed by this court on 23rd of September 2024 has been filed. Why then additional affidavit today itself will stop. The same is not on record. The copy of the said additional affidavit is supplied to the counsel for the Mr. K. N. Chaudhary, Amicus Curie, and the other.
Already furnished, Lordship.
this and oh, this given, my lord. I'm sorry.
Is already furnished to stop list this matter on 11th of November,
Lordship.
11th of November.
Deep, my lord. Affidavit reply, no?
Item 2 and 3.
My lord, in item number 2,
Yeah.
state has also filed an affidavit. We have also filed a reply. Both are not on record. Let the matter come after the Diwali. my lord.
So Mr. Mishra is also. Yeah.
No affidavit has been filed.
It's a matter, in fact, if EIL, one affidavit is enough.
No.
The stand of the state government is.
Challenging the rule.
You also.
We have not challenged the rules, my lord. We are on.
If it is
we-
a challenge by them against the rules, then the central government will be the appropriate. Because it is central rule.
Which rule is under challenge?
Central
Yeah,
Ministry of Transportation
notices of served upon-
Notices have been served.
In item number 2, dono mein hoga sheet ek bhi bana. Item
Wala kesu hoga.
EIL number 52/2024. In response to the PIL, counter affidavit has been filed on behalf of the state and the rejoinder has also been filed on behalf of the petitioners. However, the copies of the counter affidavit as well as the rejoinder are not available on record. Registry is directed to place the same on record. Stop. In PIL number 46/2024. इसमें लिख दे. In this PIL, the petitioners have challenged the validity of rule
Central motor vehicles, 11th amendment rules.
Rule which have rule 167 in bracket 5, 7 and 8 of the central motor vehicles in bracket 11th amendment rules 2020 and rule 161 167 capital A 7 in bracket 7, 8A and 10 of the central motor vehicles 17th amendment rules 2021. Stop. Since the validity of the central rules are under challenge, the Union of India is supposed to file the response. Mr. R.K.T. Chaudhary, the Deputy Solicitor General, grace 4 weeks time to file reply to the petition. To the PIL petition, time frame for is done. List both these PILs on any date of.
But other matter, there is some urgency because that pollution thing has been kept on hold.
We have already clarified that.
No,
In
Milord,
the last occasion.
pollution not, Milord.
Pollution, in fact, they.
No, Milord, there I will make our submission, Milord. Basically, the rule is not coming in the way. What is coming in the way is a notification of the government.
2 weeks.
2 weeks.
2 weeks. We are granting you 2 weeks time instead of 4 weeks, 2 weeks.
Highly obliged, sir.
1811. Item 4.
My prayer is that matter may be taken on 5th of November, next Tuesday.
5th of November.
Right.
With the request of the learning council, this repetition on 5th of November. Interim order is limited or it's.
Not absolutely.
Item 9 to 15.
Education book.
Who is the field for the state?
যাতে এখন চিঠি আছিলে নহয় কাৰোবাৰ কোনখন আছিলে প্লিজ কোনবিলাক Government itself is, Milord, of the view.
Remaining.
মানে আমার কথা হল গ্ৰেজুৱেট টিচাৰ চিনিয়ৰ হিচাপে হয় তাৰপিছত বিদ্যাৰ্থীলৈকে ভাল প্ৰিন্সিপাল হৈ থাকিব আমি নাপাওঁ আপোনালোকে আমাৰ চব আছে But we are also graduate teacher. We don't fall in the other category. Yes. NCT affiliations are high cost.
Chaudhary,
My lord.
in one of the petition, affidavit is filed along with that.
Yes, item number 30, item number 9, my lord.
9.
Yes, there's
Where-
affidavit of the NCT government,
Which number?
8682 of 2019.
No, there is a letter from the secretary of the.
Yes, yes. My lord, in this case only.
3/10/2021.
Yes, yes, yes. 3/10/21. Yes, yes, my lord. Yes.
3/10/2021.
Item number 9, page number, my lord, 246.
Item number 9, this is petition number
8682 of 2019.
86.
82 of 2019. My lord, that is the
Just
affidavit, additional affidavit by petitioner. Page 246.
246.
Yes. In fact, this was a communication by the state government to the my lord learned advocate general, as he was then the senior standing counsel. Page 246, my lord.
No, not in this.
Page 246.
Oh, affidavits. The
Item
affidavits are separately kept. Yes, it's NCT affidavit is also. 6.
246.
And on the, one of the occasion, court has asked him to clarify this position.
Yes, yes.
Mr. Majumdar was, I think so, he was the advocate. Where is Mr. Majumdar? Call him.
May I read that later, my lord?
Yes.
With reference to the above, I'm directed to say that the Secondary Education Department had filed an affidavit before the Honorable Guwahati High Court in connection with WPC number 8682 of 2019, wherein it is mentioned that B.Ed is not required for promotion to the vice principal in provincial high secondary school. It is stated that since B.Ed is compulsory for recruitment to the post of principal, postgraduate teacher, graduate teacher, and also for promotion to the post of headmaster of provincialized high schools, and also for post of vice principal in government higher secondary school. Therefore, B.Ed should also be made compulsory for promotion to the post of vice principal in provincialized higher secondary schools. It's a clear stand of the government, Miller.
They even asked to recall that affidavit.
Exactly.
Shall be made compulsory for the vice principal and.
In any case, my lord, exercising power under entry 25 list 3, you cannot override, my lord, entry 66 list 1.
Yes, Mr. Majumdar. The court has issued a direction to you or granted time to you to respond to the letter dated 3/10/2021.
That affidavit was filed, my lord, if I'm not. The department has instructed to continue the case, my lord.
Two,
To continue, my lord, that was issued by an additional secretary, my lord. The government, it was not the government's decision to,
secondary to the education department.
my lord, yes.
And again, secondary to the education department has written a letter on this 23rd of February 2022 also.
My lord, I had instructions to continue the matter. That was not the decision of the government. It was his personal letter, my lord, sort of a personal thing that
Yeah, personally.
I had given a affidavit, my lord, if I'm not wrong. An affidavit was filed, my lord.
Lord, under the General Clauses Act, even under secretary is also government.
No, but it was not the decision of the government. There was no file noting to that effect. That such a letter is required to be issued.
Where is your affidavit in counter to that?
Yes, only. But yes, my lord, that affidavit perhaps. Lordship will have it on Monday, my lord, I'll place it out. It's not there in my file also. But there are instructions, yes, my lord. There are instructions.
There are instructions, there is a clear cut direction that recall your affidavit and file afresh while saying that it is necessary for that end. And ultimately, what we
My lord,
find,
when I,
this justification of yours
my lord,
not to provide this B.Ed qualification since many of the persons they are going to.
There are
retire and
earlier
no
judgments
promotion
of this
avenue,
honorable-
Therefore, we have granted what?
no, there are
you
other,
have to do.
there are earlier judgments of this honorable court which says that this may be required, this may not be required. It is up to the department to decide it. So therefore,
Okay, that simply because they have no avenue of promotion and therefore you gone away with the B.Ed qualification, that can't be a
Madam, this-
justification, even though if you can do it, some reason, plausible reason should be there.
the reason is, my lord, that there was an earlier round of litigation where
New education policy to B.Ed পয়সা না? এই তো কথা মানুষ কাবার কোথায় করে না এটা করে দিছে।
Mr. Mujumdar,
my lord,
earlier the situation was that B.Ed was not a required mandatory required
Exactly.
qualification for induction into the service as a teacher, right? 2012 amendment comes wherein B.Ed is made a mandatory qualification.
True.
Now, vice principal post is not a direct recruitment post. It's a promotional post.
it is the senior most person who comes into from the school.
Now, when the cadre below, the feeder cadre, it is a mandatory requirement that it should be B.Ed.
For a teacher, not for the an administrative post, my lord. That is the issue.
No. It's a promotional post.
So she could have one
Vice
judgment of,
principal is
division
the-
bench judgment of this honorable court, my lord. The logic why we had to go with that.
That pertaining to that this inspector of schools.
B.Ed
Inspector
required
of schools.
for the post of principal or not? Kanak Chandra Das.
It cannot be. Now you have made it. Why have you made it compulsory for principal then?
The Roshi will kindly have the judgment, my lord. Will. Yes.
অনেক সুন্দর দাস কোনটো
Roshi will have
No.
page 6 and 7, my lord.
এক্সট্রা কপি আছে নাকি?
Then, Mr. Mujumdar,
My lord.
why did you make it compulsory for principal and not because it's an administrative
Because
post?
principal being the highest post in the school, who administers the entire school, while the vice principal is only a post which is for the senior most teacher.
That's what my lord was saying, that if you have it for the highest
We
post,
are not
why
showing,
are you not having it for the post of vice
we
principal?
are not, that is because it is a totally, the duties and the nature of duties discharged by both the posts are different, my lord. It is not a principal
In the
and a vice
absence of
principal cannot be
principal-
equated,
In the absence of the principal,
my
who
lord.
is going to discharge the duties of principal?
Only the day-to-day discharge is done by the vice principal, my lord.
Vice principal.
Vice
right?
principal.
For the purpose of principal, B.Ed is required and for the discharging duties of vice principal.
This matter,
principal, the vice principal is not required to.
in this particular case, which I have given before lordships, this honorable court was of the view that even for principal, the B.Ed would not be a necessary qualification. Giving B.Ed for post of principal is not
Then-
correct, is what this
Then
honorable
why,
court.
why you have?
Because we had-
Prescribed
we
the
had-
qualification of B.Ed for the principal.
Madam,
And,
because
when
Lordship
this
will kindly-
court has already mandated, why you have prescribed?
It is not mandated. It is not mandated. It says that it will be hard on the principals to have B.Ed degree. It's there, my lord. You cannot deny people.
When we give qualification of post principal does not arise to the not to be put. There is no conflict with qualification. We also this is in the context of the building the system. Today it's 2018. And then there is a clear infrastructure.
Then there's another matter, the all Assam higher
That
secondary.
is, that is in respect of the rules which.
No, in
were
this
in
case,
force at
my
that
lord,
time.
in this case, the issue was as far as headmaster B.Ed is prescribed.
Yes.
Therefore, this honorable court says based on the Supreme Court judgment that there can be a basis for classification based on higher qualification. How this judgment come to the rescue of this thing?
Then lordship will have this judgment matter. All Assam higher secondary teachers employees association state of Assam. Their lordship will have paragraph 3 onwards.
Amendment rules.
Paragraph 3 onwards lordship will have. Any paragraph at paragraph number 7.
ইয়াতে teacher
That is,
নাই
that is
headmaster
distribution.
আছে।
You just see,
সেটাই তো কথা।
according to the petitioners, the requirement of PTBA. degree is arbitrary in national for the category of postgraduate teacher or vice principal recruit. As for recruitment to the post of postgraduate teacher, neither at the time of entry into service PTBA degree is required.
The same thing, my lord. When
Here,
when
here
these teachers, when-
now what the brother has pointed out.
Hmm.
That since at the entry level, for the purpose of this, you are, you have prescribed the qualification BA.
Reverse
And,
situation.
From those, this is that is the feeder cadre. For the feeder cadre, qualification is BA, and for the promotional for qualification is not.
Well, here it is reverse case.
Lordship
Here
will see-
graduate teacher, it was not required.
lordship will see a paragraph 7.
Ah.
Lordship will see a paragraph
This
7.
judgment can help.
No, lordship will see paragraph 7 for a
Where
moment.
is that? Where is that your affidavit? You just show us.
But
What is
that
the
affidavit
justification
perhaps-
for that?
Lordship will give me a day's time.
Legal.
If not filed, I'll file it, but it was
Wednesday.
there.
Legal,
Wednesday,
When,
sorry, Thursday,
4113.
seventh of November.
Okay.
otherwise, lordship will have a look at paragraph 7, my lord, lordship will find it.
That is in context of rules in vogue at that
Manoj
time.
Chandra Das, na?
These rules, my lord, where,
2018 rules.
my lord, 18 rules, the teachers who continue without a
But yet
BA.
reverse case.
They continue without a BA. The same teachers are before lordship.
In fact, requirement of B.Ed was upheld, saying that for promotional post, you can always make a classification.
Item 17.
Yes.
His lordship. Here we have taken two grounds for challenging the order passed by the director, rejecting the application filed by the petitioners, seeking for transit permits.
Yes.
Second is, my lord,
Yes.
8 SSC 534.
Per second.
What is set purpose? Agreement husbandry and and for transportation of so trade. What is set for trade also is not there. Trade agents. Of farm. There is nothing else in packing it, pouring. Permit from the people it's only for ini dengan desain dengan melihat repetitive become addition with 181 second 6. Because they could not two people.
You are seeking permission for this transportation of cattle for what purpose?
My lord, for trade purposes. For trade purposes. My lord, initially, my lord, the Assam Cattle Preservation Act 1950, it doesn't require transit permits from the state of Assam. Now-
You are seeking this permission to transport the cattle from West Bengal to Meghalaya
Wait.
for what purpose?
My lord, for trade purpose.
Only for trade?
To
purpose,
trade
Not
purpose.
for slaughter?
Yes, no. Now, there is
Where
any,
is that clarification?
My lord.
Because the state in its affidavit has made a specific allegation.
Right.
Just see page number 108.
my lord, may I just come to affidavit? 108. My lord, 108, my the state has taken put the allegation that it is not for, my lord, it is for the slaughter purposes. My lordship may come to my affidavit. My affidavit,
Affidavit
my lord, affidavit filed by me.
on
Lordship, may kindly, I file affidavit on my lord, my lord 30, my lord, running page number 96, my lord. 96. my lord. Pursuant to the permission given by this court, I put up the application. And this is the affidavit. And may I straight come to the form, the application form which I have placed before the appropriate authority.
Yes.
Lordship may kindly come to page number 101. This application was put up, my lord, on the suggestion of the learned HE during the pendency of the petition. My lord, may kindly see any other reason, please specify for trade. Right. Now, this is in pursuant to my lord, section 7, subsection 4 of the Act, amended Act. And in that Act, lordship available, lordship kindly come to page number, my lord, 62 of my requisition. '62. This is the amendment 1, notified on 28
Yes.
January. My lord, may I come straight away to the amended provision, page number 63.
Yeah, that
Yeah. So the purpose is,
they were restricted only for the this agency or farm registered under so and so and not for an individual.
my lord, that is one of my grievance, my lord. They have restricted
That is your main grievance.
main grievance.
That
Now,
is
my
your
lord,
main grievance.
therefore, I challenge the validity of those provisions. Now, without entering into that, my lord, issue, my first limb of argument, my lord, rejection passed by the director on the ground that my application is only not for the agriculture or husbandry. It is contrary to the act itself. Therefore,
This-
is contrary, is the violation of the section 7(4). Now, if lordship is persuaded with this first issue, I don't need to enter into the validity of the act. But I would demonstrate with lordship
Yes,
permission.
Mr. Sekhya. See, this, when this rules were enacted on 15th of September 2021. Page number 54. Page number 54,
Lordship,
subsection 4.
subsection 4.
Yeah.
Notwithstanding anything contained in subsection 1, 2, and 3, the competent authority may issue permit for transport of cattle for bona fide agriculture and animal husbandry purposes as prescribed in the rules framed under this act.
Now, at the time, from this can be gathered that any person can move an application for the purpose of transport or animal husbandry purpose. Now with the amendment, this page number 63,
Lordship,
you have amended this rule 4.
yes,
read
Roman
this.
3.
This Roman 3,
Notwithstanding anything contained in subsection 1, 2, and 3, the competent authority may issue permit to any agency or firm registered under the Animal Husbandry and Veterinary Department, Assam, for transport of cattle for bona fide agriculture or animal husbandry purposes or for transportation of cattle for trade for the said purpose.
Now it seems that you have restricted these only to the registered agency or firm
Lordship.
with the, not to the individuals. So you have narrowed down, in fact, the scope of moving that application. What is the justification for that?
Individual is not here.
Individual, in fact, earlier it was open for the individual to move an
Lordship.
application. Now you have restricted only up to the agency or firm. Now, this seems to be in direct conflict with this Article 19 and Article 301. What
But
is
that,
the justification?
yes, Lordship, that is a very valid point Lordship has raised, but this was not the case.
This is the only case. Sir.
No, according to them,
No, this is the only case. You just see this.
our case is very simple. We are not rejecting him whether he's individual or firm.
No, there's a ground number and this. You just see ground number 1 of the petition. From the influence subsection so and so, so and so, why the empowering the company issue permit only to an agency and firm registered under the so and so, so and so. Again, they have reiterated the same in ground number 2. For the influence subsection narrowing down only to the registered agency or firm with the animal evidence so and so, so and so. This is what their main defense is.
Yes, Lordship, but our rejection is not on that ground.
Sir,
We can always get it corrected. But his case is that not as only because as an individual.
What we feel that yes, the state authorities has full right to examine that for what purpose. And
It was examined also.
They have to show their bona fides.
Yes,
only
Lord.
for the
They
trade
failed to
purpose
do
they
that.
are doing. But this, in fact, this sub-rule 4 of subsection of rule 7,
Lordship.
in fact, clearly restricts the right of an individual to move an
Lordship, that can be rectified. That I have no difficulty in. We can get it done. But his case was,
so thereafter
he had to,
the right to check the bona fides of a person who is making an application. for
and
that.
therefore, in fact, Lordship, in the meantime, he was directed to give an application. He applied and we considered his application.
Then what happened?
My lord,
What
the
happened
rejection order is here again. Submitted by the agent, may I just submit?
Ah.
My lord.
The reason is
application
that he could not bona fidely establish before us that it will be for agriculture or for animal husbandry trade purpose. He could not establish that.
Then you cure this effect that any person.
Yeah, that will correct.
And then
Or Lordship may read it down also to that effect. I have no.
down in the sense, if the state government can do it.
Lordship will kindly give me time. I'll get a instruction from them that we are going to amend it. Only inserting that individual also along with agencies and firms.
Just show us that from where you gather, once he moves this application, that we are only seeking permission for transportation of this cattle for trade purposes.
Lordship.
So what is the material with you that no, they are not seeking this transport permission for the trade purposes and only for the slaughter purposes? There must be some material for that. There must be some material with that. Yes, it was. How you come to this conclusion? On what basis?
Sure.
And Lordship may take the pain to produce the last order, rejection order. The ground taken by the government is, my lord, it is not bona fide or bona fide agriculture or husbandry.
Yeah, it is already.
Lordship, let me examine the records, what application they have said, because our case.
Ultimately, sir, for the reaching out this satisfaction that this applicant is not bona fide or for whatever. What is the material? Simply while saying.
Lordship may, in that line, without touching the act, Lordship may direct us that we will examine again. Let him establish. He was given an opportunity by this honorable court also earlier. If he establishes, because we have no business of stopping if it is for genuine bona fide business purpose. But the issue is, Lordship, it is ultimately, it will end up in slaughtering house. In fact, Form C is very clear.
Yeah, yes, it- Cannot be only for the purpose की उन्होंने ये दोनों कॉलम फिट अपने सही से what they can go and differently लिखे हुए हैं what हमें will feel very good ये तो सही होता है नहीं सही होता है नहीं लगता ना जो देखो बोलना निकाले गवर्नमेंट करते
But, Mr. Secretary, you have to satisfy us that while rejecting his application, that this application is not moved for the purpose of so and so, so and so. That is, you must have some material.
Yes, Lordship.
And-
One
and,
thing, what we ask for that if he is for trade purpose, then we ask for the trade license.
Now
He
this
failed to.
latest your application rejection hai, what you have said, in view of the above, the representation of the petitioner are hereby rejected, disposed of with advice to the petitioner to register the farm agency provided under so and so for trading and cattle for bona fide and annual purposes. This is what the reason you have rejected his application. Okay, you are not registered as a farm
He is not a
agency.
trader there. If he is saying it is for trade purpose, he must have a trade license.
Have you asked him?
Yes, we asked him.
No, no.
Where is that material? Have you asked him where is your?
My instruction is very
license
clear
and
that
all?
he failed to establish that he is a trader.
Whether you issued a show cause notice to him, ke, show us your bona fides that you are a trader or something else.
Lordship. Because we are more concerned about protecting the Lordship. This is a small issue. This is the issue which Lordship now is now cropping up before this one.
First
That is a
issue-
very small issue. We'll definitely.
First is that you have restricted this application of Rule 4 only to the registered agencies of town and not to, and excluded the individuals as such. First is this, and second, essentially, you may have rejected the first application on whatever ground, but after direction from this court, the second application is rejected only on the ground that you are not registered as an agency. This is what, and even though the state has every right to check the bona fides of such person, to
Lordship.
apply for that, but for that purpose, while framing an opinion, there must be some material.
Yes, Lordship. I fully agree, Lordship. Let me examine and I'll come back to it. And in the Form 3, Form C, Lordship, where he has to apply, it is just an individual. But
this-
Act is little bit different, Lordship.
So it is always open for them,
Yes.
even though if he shows his bona fide,
Lord.
you are not registered as an agency.
Lordship,
therefore you are
if
out.
he's a genuine trader, Lordship, if he's really taking it for animal husbandry
And
purpose,
it is
we
always
have no
open.
business
If
to stop it.
Any person you have any doubt, you can very well issue a show cause notice or ask him to furnish the details that you are a trader.
Lordship.
Then you can just-
Yeah, most probably it has been
Lordship,
done, but
please,
maybe in a very casual manner. But
My lord, will not subject lordship, if AG examine the matter, and my lord, consider the matter within the time frame, my lord. I'm
we-
seriously affected.
not
They are simply, their advocate generally seeking time to look into this.
only 1 week's time.
For 1 week.
1 week. In the holidays will also pass by during this time. Now, our concern is that Act should remain in the, these are minor issues, Lordship.
No doubt about that,
Lordship.
about your concern, sir.
And if it is for bona fide purpose, Lordship, why should you stop?
17th.
12th of November,
Lordship,
Based on 12th of Feb.
My
highly obliged, Lordship.
deeply obliged.
Item 19 and 20.
Only 19 to 20.
My lord, initially, when we moved this petition, that advertisement, that date was not notified. And now, my lord, online applications has been called for, and the 21st of from 21st of October till 15th of November. So that is how, my lord, we have mentioned the matters, and our matters are listed. Now, our basic grievance is, my lord, the NCT guidelines are mandatory, and the state cannot prescribe anything which is contrary to the NCT, my lord. That is the main crux of the matter. If your lordship kindly takes the writ petition, my lord. Page 36. My lord, this is the certificate that the petitioner number 1 has cleared 10, securing, my lord, 118 out of 200. So it is certified that this mark sheet cum certificate will remain valid for 7 years from the date of issue of this certificate, and will only be valid subject to production of original certificate record to the concerned authorities in due course of time. Now, my lord, at page 56 up to page 55 are the different certificates. Now, kindly see, my lord, page 56. This is again elementary. Anyway, my lord, this is applicable in case of elementary. We are not really concerned.
Page 56.
Yes, my lord, that is that as far as elementary is concerned, this certificate is valid for lifetime. Yes. Now, what had happened, my lord, what the state has done, please come to page 58. This is what is under challenge. In exercise of the powers conferred by proviso to Article 309 of the Constitution of India, the Governor of Assam is hereby pleased to make the following rules. Further, to amend the Assam Secondary Education Provincialized Service Rules 2018, hereinafter referred to as the principal rule. These rules may be called Assam Secondary Education Provincialized School Service Amended Rule 2023. We are basically concerned with, my lord, amendment of Rule 8. In the principal rule for the Rule 8, the following shall be substituted, namely, recruitment to the post in the cadre of postgraduate teacher and graduate teacher, including subject teacher in vocational subjects, shall be made by direct recruitment through teachers' eligibility test cum recruitment test, hereinafter called TET cum recruitment test, to be held as per criteria mentioned in Schedule 2 and in the manner hereinafter provided. So, my lord, despite the fact that we are already TET pass.
Earlier Rule 8.1 was.
Yes.
Page 20.
Itu. 2018 है, एक होने को 18 page. It starts at page 18 of that book, my lord.
Rule 18. Late.
The recruitment to the post.
Schedule 2.
রুল করে সাবস্টিটিউট করে দিন।
Sorry. Schedule 2 at 8:40. The person.
Anything to
Now the qualification is on the schedule.
nothing.
Post graduation.
Yeah, people prescribe for this, right?
Economic
No, no.
sorry. Post graduation. Recognized universities.
Yeah, okay, primary school and the like. Okay. Relaxes. Relaxing বলবো পারে।
Not else be economic.
Schedule 49. The marking process. 100%. That is. Something for 15 days. Definitely. 100, 200. कितना मिलेगा उतना नहीं। उसमें भी as we can do, I think I
original rule is in the tap আছে না? আসলে আমি রুল 10 টু চ্যালেঞ্জ না আমার মতে আসল কিন্তু আমার যদি রিল্যাক্স করে পার্টিসিপেট করবো দিয়ে হয়ে যায়।
और टेक्निकली तो 5 नंबर में पर मान लो 5 नंबर का कितना in addition you do me पूरा 100% नंबर अभी schedule 2 यहाँ पे page 60
before this যদি আমি অ্যামেন্ডমেন্ট যাই হেতু আহি যাব তেতিয়া কি হ'ব
बोल दिया कि 1 months तक 2 पेपर और 1 in addition to that
আমার বিদ্যাত আছে
Stand here, sir. Wait. Provisions of the rental permit is applicable only for development. And it is enforceable for applicable. Eight. So, because education. Despite advertisement issue, the criteria later on.
Yes. My Lord, Lordship has seen by this amended Rule 18, a TET-cum recruitment test has been prescribed, which is under challenge.
For postgraduate and graduate teachers.
Yes. NCT does not prescribe me TET. NCT prescribes for elementary.
Only element.
Yes. Now please come to page 59, my Lord. Amendment of Rule 10. Actually, it's an open and shut case, my Lord. It's purely outside the jurisdiction of the state. In the principal rule in Rule 10, for sub-rule 1, the following shall be substituted, namely, the academic and professional.
Amendment. And now the amendment, what they have done, they have 10 to 1. To the academy for that one shall take attention in addition to it as number 1 will be chosen in addition to the academic and have to appear in the as per rule. So here to with
RT Act of 2182, section 21A. Primary. 21A. Like I can report it.
Yes.
Yes. My Lord, at page 59, I was referring to amendment of Rule 10.
Then, yes.
2. In addition to such academic and professional qualifications mentioned in sub-rule 1 above, for direct recruitment to the post, all candidates shall have to appear in TAT-cum recruitment test as per Rule 8 of these rules. So this is also under challenge, my lord. And Schedule 2 also is has been amended at page 60 as to the component of the teachers' eligibility cum recruitment test has been prescribed. It would be of 250 marks. Paper 1 shall be 150 marks, the pedagogy, 50 marks about the assemblies and its people, 50 marks, etc., etc. So these are the, my lord, criteria. Then my lord will kindly come to page 62. Second page. This is the second amendment. Now, if your lordship could kindly see, in exercise of the power conferred by proviso to Article 309 of the Constitution of India, Governor of Assam is hereby pleased to make the following rules. Further to amend the Assam Secondary Education Service Rule 2018 is second amendment. Then 2.2a. The criteria for selection of graduate teachers, postgraduate teacher, including subject teacher in vocational subject, teachers eligibility cum recruitment test, 140 marks. Earlier it was 250.
Instead of 150 there.
250. 150. Yes, yes. Now, my lord will kindly come to page 63. Now, this is the lollipop which has been given to us, my lord, to Roman 2.
It's a lollipop, take it.
So, my lord, it's sour.
So,
It's not sweet.
Yes.
Candidates who have passed the earlier higher secondary school TET and not been appointed till date will get weightage of 5% of the mark secured in respective TET or maximum 5 marks for selection as a graduate, postgraduate teacher. Now, my lord, matter is very simple. Now, I'll place the NCT guidelines, my lord. Take a note, huh? NCT, my lord, does not prescribe TET. Please come to page 6 of this notification, my lord. First schedule. Page 6, left hand top, my lord. Legible only. কি দিছে আইকন? Huh? ভুল only. One second. Huh? আরে এখন দিদি my lord, in this second writ petition it is annexed. এখন দিদি my lord, may kindly have. I'm sorry, my lord.
Yes.
Page 6, my lord, towards the bottom. Secondary high school for class 9-10. Graduate, postgraduate from recognized university with at least 50% marks in either graduation or post-graduation and Bachelor of Education B.Ed from National Council for Teachers Education recognized institution. Or graduate, postgraduate from recognized university with at least 45% marks in either graduation or post-graduation and Bachelor of Education from National Council for Teachers Education recognized institution in accordance with the National Council for Teachers Education form of application for recognition, the time, etc., etc., etc. Regulation 22 notified on 13/11/2002 and National Council for Teachers Education, so and so. Or 4 years BA degree, BSc degree from any National Council for Teachers Education recognized institute. So, my lord, as far as 9 and 10, that is the qualification prescribed. If your lordship would kindly come back to the earlier page, my lord.
Yes.
On top, then preschool nursery followed by so and so. What is it? কিয় ক'লা এইটো বহিবৰ কাৰণে? কি আছে?
23, 2010, you know,
Oh.
that,
Oh, Millard will kindly come to serial number 3, Millard.
3.
Yes. Minimum qualification as laid down by National Council for Teachers Education, wide notification dated 23/8/2010, as amended from time to time, issued in exercise of the power conferred under subsection 1 of section 23 of the right of children to free and compulsory education. Well, this refers to private elementary education and where TET is prescribed
In the, this.
in respect of elementary.
In white notification 23.
3/8/2010, Miller.
The stat is prescribed for the, this pre.
Only elementary.
Primary and upper primary.
Yes.
Fine.
Not for secondary and higher secondary.
Page 79.
এইখনত আছে নেকি? এখন আছে না?
Yes.
এইটো টেট পালে এইটো। Now, Millard will kindly come to the next regarding 11 and 12.
Notification 23rd of August 2010 is annexure A.
Yes.
Affidavit of the NC.
Affidavit of the NCT, Millard.
Page 18.
Yes.
Yes.
Yes. Now, Millard will kindly take the next page, Millard. What is it? Yes. I was referring to that regulation, Millard. Page number
27.
Regulation, this,
regarding 11 and 12.
11 and 12.
Yes,
yeah.
there is also no prescription of TET.
In this,
Yes,
yes, there is no prescription of paper.
TET. The question is,
In accordance with white notification 23/8/2010, there is a provision for PET.
only regarding elementary.
Element.
Yes. Now the issue is, my lord, if the NCT has not prescribed anything, whether state can. That is the issue, only issue. My lord. Now, in that regard, my lord, let me place our averments in the writ petition, paragraph 16 for a moment, my lord. My lord, the rules of 2018 as it stood before amendment, it prescribes that if the selection is conducted according to that rule, we have no objection because we have cleared 10. But it can't be in the form as is sought to be done now. Please come to page 22, para 16. That the petitioners beg to state that the impugn amended provision of Rule 8, 10(1)(2) and Schedule 2 of the amended service rule brought in wide notifications that it's so, compelling the petitioners to sit again in TET examination, apart from being violative of the decision of the NCT, that validity of TET certificate would be valid for lifetime is also arbitrary. NCT regulation of 2014 have been framed in exercise of the power conferred under provisions of NCT Act 1993. The NCT Act 1993 has been enacted by the Parliament with reference to 66 of the 7th Schedule List 1 of the Constitution. There is no such specific power vested in the state legislature under Schedule 7 List 2 to make laws in respect of education. Entry 25 of Schedule 7 List 3 provides the field for legislation both to state and the center in relation to education, including technical education, medical education, and universities, vocational and training, technical training of labor. The field of education is primarily covered by the union list. Thus, state can exercise legislative power under entry 25 list 3, but such law cannot be repugnant to the central law. It is a trite law that wherever the state law is irreconcilable with central law, the state law must give way in favor of the central law, to the extent of the repugnancy. What is further noticeable is that impugn amendment is ultra-vires on the failure of the state respondents to follow the procedure prescribed in Article 254(2) of the Constitution of India. As such, in the humble submission of the petitioners, the impugn amendment provision of Rule 8, 10(1) and 10(2) and Schedule 2 of the amended service rule of 2023 brought in by notification dated 29/2023 and 13/12/2023, compelling the petitioners to appear in seat are in violation and repugnant to the constitutional provision, hence liable to be struck down. The impugn amendment also suffers from the vice of arbitrariness. My lord, I would also like to read para 18, my lord. That the respondents are well aware of the fact that similarly placed TET qualified candidates like the petitioners have already been appointed as graduate teachers in different provincialized high schools and higher secondary schools on the basis of their TET qualified certificate without subjecting them to further tests. The petitioner had also applied for the post of postgraduate teachers in response to the advertisement issued by the respondent. However, as it has already been stated herein above, that the petitioners were not selected for the said post of graduate teachers as they were placed below in the merit list. In the humble submission of the petitioners, the impugn action of the respondents in taking recourse to the impugn amended provision of Rule 8, 10(1) and 10(2) of the and Schedule 2 of the service rule brought in by notification dated so and so for filling up the post of graduate teacher in provincial school has created a class between the similarly placed persons. The said classification in the humble submission of the petitioner is not on the basis of intelligible differentia, and differentia bears no nexus with the object sought to be achieved by the rules of 2018. Object for conducting TET was to recruit persons eligible for holding the post of graduate teacher in high and higher secondary school. A perusal of the impugn provision, amended provision of rule so and so, brought in by notification requiring petitioners to appear and pass TET once again would clearly go to show that there is no nexus with the object not to be achieved by the said notice. So, my lord, basically, we are saying, my lord, it is not within the competence of the state to make a law which overrides the central law. And secondly, my lord, by creation of the class within the same class of people, Article 14 stands valid.
You already appointed.
Yes, yes. Now, I'll place two judgments of the Supreme Court straight away on the point. One judgment of our High Court, my lord, division bench, based on the Supreme Court judgment. My lord, this is 2024 GLT 842. Milord will kindly come to para 14, Milord. But I am holding GLR. I think paragraph should tally the sentence starting with Right to Education Act 2009.
Yeah,
Yes,
it
yes.
was brought in by the.
Yes, yes, yes. The Right to Education Act 2009 was brought in by Government of India, making education compulsory for children up to 14 years. By this statute, a key change has been brought in about in the field of education from primary to secondary level by bringing in several requirements and parameters which are to be maintained by the state in respect of the school management authorities as well as the qualification desired from teachers seeking employment as such. As for the provisions of the Act, the qualification and terms and conditions of service of teachers are to be laid down by the academic authority as authorized in this regard by the central government. Much prior to the enactment of the RT Act, central government had established a council to be called National Council for Teachers Education under the National Council for Teachers Education Act 1993. The Constitution, the power function of the NCTE are as provided for under the said Act. After enactment of the RT Act, the central government by notification dated 31st of March 2010, which was published in the Gazette of India dated 5th April, notified the National Council for Teachers Education to to be the academic authority to lay down the minimum qualification for being eligible for appointment as teachers, as also the curriculum and evaluation procedure. Thereafter, the NCT by notification from time to time laid down the minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in clause 9 of section 2 of the Right of Children to Free and Compulsory Education Act 2009. In view of the notification published by the Government of India, authorizing NCT as the academic authority to lay down the parameters with regard to qualification of teachers, the selection process, the curriculum to be imparted to the student, the evaluation, etc., all are required to be set by National Council for Teachers Education. These are then notified by NCT by notification from time to time and are published in the Gazette of India. The state of Assam is required to mandatorily adhere to the parameters as laid down by the NCT from time to time. I am on this, my lord. Then my lord will kindly come to paragraph 23. Now please come to para 22 at page is not telling me, lord.
Accordingly.
Accordingly, the merit of all the candidates, including the petitioners of Karimganj districts, were prepared on the basis of marks scored in the above mentioned examination or achievements. The department contended that the recruitment qualification for appearing in TAT examination and requirement process are two separate processes. But the petitioners have mixed up both the issues in the petition. Respondent department contended that recruitment process was conducted strictly on the basis of the guidelines as laid down, guidelines as notified by notification dated so and so, read with guidelines of NCTE. The department contended for recruitment of teachers in lower primary school, there is no provision for assignment of marks against the graduate degree while preparing the select list of candidates on merit as per the requisite academic qualification in the NCT notification, as well as the state rules as stated above. Once the documents of the candidates were verified by the district level scrutiny committee, verification committee, it assessed the merit of the applicant by taking into consideration the academic record, professional qualification, TAT scores for preparation of the merit list of the candidate as per the guidelines dated 23/7/2014. The department contended that the candidates was prepared accordingly, including Karimganj district on the basis of the total mark scored by each candidate in the manner provided for by the guidelines. Department contended to bring about transparency in the process of selection of teachers. The selection of candidates were made strictly in order of merit as per the aforesaid notification guidelines dated so and so, and no deviation was made therefrom. The consistent stand of the respondent is that the selection was conducted strictly in terms of the provisions of 1977 rules read with RT Act and NCT guidelines issued from time to time, and it is seen that on the basis of the guidelines dated 23/7/14 issued by the department, the selection was conducted. It is contended by the respondents that petitioners were not selected as they failed to satisfy the requirement of having 50% in the higher secondary examination. As the said guidelines, there was no provision to allot any marks for graduate degrees obtained by the petitioner. Consequently, the respondent authorities did not consider the candidature of the petitioner as they failed to obtain 50% marks in the senior higher secondary. What had happened, my lord? The prescription was 50% in the higher secondary. They did not secure that. Instead, they were graduates. So there was a prayer made. Why not the weightage of graduate be given? This honorable court says it can't be given. Now, my lord will kindly come to page 30, my lord. Para 30. Para 30, my lord, the NCT notification of 23rd August 2010 is quoted. Then my lord will kindly come to paragraph 36. Yes. The accrual of any right of any candidate towards selection and appointment to any post under the government will have to be determined keeping in view the parameters laid down in the service rule governing such recruitment. In view of the provisions of NCT Act 1993, RT Act, and all notifications issued by NCT will have to be given primacy in the area of qualification laid down for teachers and process of selection of such teachers. The primacy, my lord. The Supreme Court in recent case relating to prescription of qualification for recruitment of teachers by the state government held that state government was under an obligation to act as per the notification issued by NCT and not to give effect to any contrary rule. The Supreme Court in this case had the occasion to deal with inter alia, the notification dated 23/8/2010 issued by NCT, which is also relevant for the present proceeding. Question which arose in the case is that central government under section 23 of the RT Act has the power to lay down the eligibility condition for appointment of teachers for elementary education, whether the NCT could not lay down any guideline so as to affect the power of the state to prescribe norm for selection of a teachers consistent with the qualifications under section 23 of the RT Act. The Supreme Court held that state government was under an obligation to act as per the said notification and not to give effect to any contrary rule. The relevant paragraphs of the judgment in case of state of Uttar Pradesh versus Shiv Kumar Pathak, so and so. My lord will kindly come to the quoted portion, para 17. There is no manner of doubt. Has your lordship got it, my lord? Yes. There is no manner of doubt that NCT acting as the academic authority under section 23 of the RT Act under notification dated 31/3/10 issued by central government as well as under section 12(12)(a) of the NCT Act was competent to issue notification dated 23/2010 and 11/2/11. The state government was under an obligation to act as per the said notification and not to give effect to any contrary rule. However, since NCT itself has taken the stand that notification dated 11/2/21 with regard to the weightage to be given to the marks obtained in NT is not mandatory, which is also possible interpretation, the view of the High Court in quashing the 15th Amendment to the Rule 81 rule has to be interfered with. Accordingly, while we uphold the view that the qualification prescribed by NCT are binding, requirement of weightage to TET mark is not mandatory requirement. My lord, in fact, by this 11/2/2011 notification, the stand which was taken by the central government and the NCT before the Supreme Court was that this is not mandatory. No, that therefore no weightage is to be given merely because somebody has said. Now, my lord, I have placed the judgment for the proposition primarily, my lord, under entry 66 list 1. It is for the central government either by itself or through some organization or agency to lay down the academic standard. And that is binding on everybody in this country. If any state legislature, if any state authority comes up with any prescription which run counters to the, my lord, prescription given by either UGC, NCT, etc., my lord, then it will not be operative. It will have to make room for the NCT guidelines. And that's a settled proposition of law, my lord. There are up to number of decisions on this point. Now, in this case, my lord, if your lordship would kindly take the affidavit filed by the NCT, which is also important. The affidavit starts at page 75.
Yes, please.
Paragraph, my lords, paragraphs 3 to 6 at page 76. The stand-up para 4 onwards, my lord, at page 77. The answering deponent begs to state that NCT has laid down the minimum qualification for school teachers by notification dated so and so. That NCT has prescribed TET for recruitment of teachers in class 1 to 8. In terms of the decision taken by the general body of the council, the validity period of TET qualifying certificate for appointment, unless otherwise notified by the appropriate government, would remain valid for life. the letter so and so. Para 6, that your humble deponent begs to state that NCT regulation related to minimum qualification for a person to be eligible for appointment as a school teacher are followed by states of India, and as such same is also applicable for the state of Assam for requirement of school teachers. So their stand is very clear and unequivocal. So the NCT guideline is binding.
Yeah.
Your Lordships would kindly take the Constitution for a moment, my lord. Your Lordships would have Article 256 and 257. The executive power of every state shall be so exercised. 256, my lord. The executive power of every state shall be so exercised as to ensure compliance with the laws made by the parliament and any existing law which apply in that state. An executive power of the union shall extend to the giving of such direction to a state as may appear to the government of India to be necessary for that purpose. 257. The executive power of every state shall be so exercised as not to impede or prejudice the exercise of executive power of the union. An executive power of the union shall extend to giving such direction to a state as may appear to the government of India to be necessary for that purpose. Not even going by the constitutional scheme, the state will not do anything which will impede or impinge upon either law or an executive instruction issued by the union. That's the scheme of the whole constitution, my lord. My lord, there is a division bench judgment of the Allahabad High Court, which I think, my lord, is relevant, my lord. Paragraph 8, no? If your lordship would kindly come to para 43, my lord. In the full bench decision of this court, passed in the case of Bijay Kumar Singh versus State of UP, the full bench on the issue of binding nature of Act of 1993, has the lordship got it, my lord?
Yeah.
Para 43.
Yeah.
In the full bench decision of by this court, passed in the case of so and so, the full bench on the issue of binding nature of the Act of 1993 and also on the applicability of the same observed as under. The first decision of the full bench is in Shiv Kumar Sharma and second decision is in Ram Surat Yadav. In the second full bench decision, the position as it emerges after amending Act 18 of 2011 was brought into force has been summarized as follows after duly taking cognizance of the earlier decisions. In view of the amendment which has been brought about by amending so-and-so with effect from so-and-so, it is clear that NCT is empowered by the regulation to determine the qualification of persons for being recruited as teachers in any primary, pre-primary, primary, upper primary, secondary school or intermediate school or college, which is established, run, aided or recognized by the central government or by the state government or a local authority or other authority. The first proviso to section 12, however, protects continuance of the person who are recruited immediately prior to enactment of the amending act, which should not be called into question solely on the grounds of non-fulfillment of the qualification as may be specified by the council. The second proviso, however, stipulates that minimum qualifications so prescribed shall be acquired within the specified period. Subsequently, in view of the enactment of the amending act of 211, the controversy has been set at rest by Parliament having provided that NCT is duly empowered to prescribe the qualification for persons who are recruited as teachers from pre-primary to intermediate school or college level. The provisions of the Act and the regulations have been held by the full bench of this court to be binding. The regulation which has been framed by NCT are in pursuance of a legislation which has been enacted by the Parliament. Once Parliament has legislated and NCT as the delegate of the Parliament has framed regulation, all actions by the state in exercise of its rule-making authority have to abide by the rigor and discipline of the regulation which have been framed by NCT. NCT has been constituted as a central authority for the purpose of regulating a subject which falls within its statutory control in the interest of promoting the quality education. Article 256 of the Constitution requires that executive power of every state shall so extend as to ensure compliance with the law made by the Parliament. Article 257 stipulates that executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the Union. In exercise of its executive power, when the state issues an advertisement for recruitment of teachers, the minimum qualification which are prescribed by NCT must necessarily govern, and no provision to the contrary can be valid in law. The rules which have been framed by the state have to be in conformity with the statutory regulations framed by the NCT. State lacks power or authority to override the regulation framed by NCT. The minimum qualification which has been prescribed by NCT are binding on the states. Now the question is that if the state is silent, whether the provision of Central Act would apply if the act of the state and Central Act is on the same subject. Education is the subject mentioned in entry 25 of the concurrent list of Schedule 7 of the Constitution. The Act of 2093 was enacted by the Parliament and falls in entry 25 of list 3 of the 7th schedule of the Constitution. And the Act of 91 is the State Act. At this juncture, the court feels free to refer to Article 254 of the Constitution, which deals with inconsistency, repugnancy between the law made by the Parliament and law made by the legislature of the state. As in the instant case, 2 statutes are of the Parliament and other statutes are of the state of UP operating in the same field, including the so-and-so. Apex, any matter, these are all known propositions of law, my lord. Unless you reserve the bill under sub-article 2, and then otherwise, my lord, it will not be operative. Therefore, my lord, the issue seems to be clearly well settled.
You said that the NCT guidelines are mandatory.
Mandatory
State
and
this
state cannot prescribe.
contrary to.
Yes. My lord, one more judgment.
Even
179. My lord, this was in the context of the UGC regulation, but the view is same, my lord. 2022 5 SCC 17.
Please, judgment, please. This is absolutely, there are 5-6 judgments on this UGC regulation. And we are so confused. Earlier it was argued and this, please.
Anyway.
These, so that is neither here nor there.
Well,
You will find, I don't think how many judgments on this, and still the things are not.
anyway, my lord, that 2018 judgment is clearly on the point.
Madras, Mati, then come.
Kalyani Matibhana. Anyway, my lord. So therefore, my lord, as far as
One
this,
question there, that now you are saying that since you have already qualified the TAT,
yes,
and that is for the valid for the 7 year.
yes.
So that qualification was also under the whatever.
State prescription.
Here now you are arguing that the
No, my
state
lord,
has
what?
no right even to.
Exactly. No, my lord, no,
So
my lord.
that, what is the validity
No,
of
there
that
are-
earlier tax?
My lord, there are two ways, my lord. Rules of 2018, as it stood prior to the impugn amendments, it prescribed 10.
Though NCT has not
Cannot,
prescribed that for.
Cannot. Ideally cannot. My lord, Lordship will kindly appreciate one thing, my lord. We, the applicants, do we have any bargaining power, my lord? My lord, the other day there was, my lord, ADR for grade 4 test. Engineering graduates have participated. So this is the stage where we are, my lord. Therefore, my lord, we have no choice. To the extent, my lord, we can manage, we manage. Beyond a certain limit, my lord, we have to
We
approach the court of
understand,
law.
But the problem is
Yes.
that your prayer, that this earlier tax should also be recognized.
No, that's not our prayer. My lord, what we are saying is, supposing Lordship is convinced with our argument, Lordship interferes with the amendment. Then, my lord, this election will have to carry it out in accordance with the unamended rule.
Unamended rule,
Ah.
there also this.
No, if your Lordship clarifies there also TET is not required, well and good. But even if state insists, my lord, we have no choice. We are beggars. That's the whole problem. My lord, even Supreme Court has recognized this principle, my lord. The judgment is yes, there's a judgment, I'll place it, my lord, where Supreme Court has taken note of this aspect. There's a judgment, my lord. So, my lord, if your lordship, no, we have, that's why you said, my lord, ideally it should not be. But even if it is there, my lord, what to do? But then we have that at least till 2027, our validity is there. So any recruitment, they cannot be held under these amended rules, my lord, because it is directly contrary to the constitutional scheme. My lord, in the second judgment, everything is same. There, my lord, contrary to the NCT prescription, they say, if you're a postgraduate in economics, you must also be a graduate in economics. That is again contrary to the NCT guideline. That is the only difference in the next case.
Yes.
Sorry, next case, Miller. Item number.
This one.
I do the 1591 of 24, Miller.
But here that question is not there.
Not there. There, the only point is they're insisting on graduation in the same subject, which is not the prescription by. Bargaining power. Somesh Thapial. Page number. Next file to Divanagi. Next file. If a lordship would kindly have Miller page 45 of the other writ petition 1591. NCT context. Page 57. Paragraph 2. Paragraph 2 कोई demo कर दी 15 है क्या
Yes.
Milord, kindly come to page 45. Amendment of Schedule 3. In the principal rule in Schedule 3, in clause I, in the fourth line after the words as valid, for the punctuation mark so and so, the punctuation mark shall be substituted and thereafter the following words shall be, namely, candidates shall have to read the same subject as one of the subjects in degree level. Now, my lord will kindly come to page 57. For 9 and 10, towards the bottom, graduate, postgraduate from recognized university with at least 50% marks in either graduation or post-graduation, and bachelors of education, B.Ed, from National Council for Teachers Education recognized institute. So there is nothing like, my lord, graduation has to be on the same.
Graduate, postgraduate from the recognized university, which shall 50%.
Yes, yes.
Equivalent,
Yes.
Bachelor of Education, B.Ed degree. So this classification
Yes.
or condition
Uh,
that you will also have this pass the graduate exemption in the same subject, that is not there.
There's no-
That is not.
Yes, that is the case, my lord. And similarly for class 11, 12 also, next page, postgraduates with at least 50% marks from recognized university and B.Ed, BSc ED from NCT recognized institution. So there is nothing like that. One has to be a graduate in the same subject. This is the only difference. Otherwise, my lord, the legal argument is same. So that is my humble, my lord, that Somesh Thapiyal's judgment.
Yes.
My lord, 2021, 10 SCC, page 116. My lord, paragraphs 37, 42, and 43.
The 2021 page.
10 SCC, page 116. Para 37, 42, and 43. But I'm not having the book, my lord.
You may have one.
From the narration of facts being referred to supra, it clearly manifests that appellants were appointed after going through the process of selection as contemplated under Part 6 of 1973 Act, which indeed was an appointment on substantive basis. And since the appellants were not in an equal bargaining position and were in need of employment when the offer of appointment was made, were left with no option but to accept such arbitrary conditions incorporated in the letter of appointment, in treating it to be a contractual for a limited period, still recorded their protest while joining, but no heed was paid. When they were allowed to continue by extending their services, they remained under the bona fide belief that as their appointment is being substantive in character, they will be made permanent confirm immediately after permanent poster sanction in the Department of Pharmaceutical Science. But to their dismay, after advertisement dated so came to be notified by the respondent Settle University, no option was left with them but to approach the High Court by filing a writ petition. Then my lord will kindly come to para 42. The submission of the learned counsel for the respondents that appellants have accepted the terms and conditions contained in the letter of appointment deserves rejection for the reason that it is not open for a person appointed in public employment to ordinarily choose the terms and conditions of which he is required to serve. It goes without saying that employer is always in a dominating position and it is open to the employer to dictate the terms of employment. Petitioner who is at the receiving end can hardly complain of arbitrariness in the terms and conditions of employment. This court can take judicial notice of the fact that if an employee takes initiation in questioning the terms and conditions of employment, that would cost his or her job. The bargaining power vested with the employer itself, and the employee is left with no option but to accept the conditions dictated by the authority. If that being the position, it is open for the employee to challenge the conditions if it is not being in conformity with the statutory requirement under the law and is not stopped from questioning at a stage where he finds himself aggrieved. This principle has been recognized, Miller. In fact, my lord, key West Bengal case to Brogonath Ganguly versus Milord Inland Water Transport Corporation, then Oghornath Day versus State of West Bengal are on those lines, my lord. Yes. So that is my humble submission, my lord.
And another thing.
Hello. No.
Qualifications.
মানে লটারি কেস করে আছে তোরা দুটা বাজে মানে আনবাং গাইলে আবেদন deeply obliged. Well, with your lordship's kind permission, I have a matter. Deeply.
It is out of the. These are people. Oh. Person holding. One thing to what one thing to
Yes.
Lordship, I am little bit confused. I do not know whether Lordship is, because whether they want that or they do not want that, they have to first clarify that. Suppose they have challenged.
They want recognition of their earlier qualification which they obtained as a pet,
Yes.
and this not clear. This is not clear. And for that, this judgment they have referred here, we don't have bargaining power at that time. This was the provision. Now they can't.
Now, these are eligibility criteria, Lordship. There is no question of bargaining here. It's from the open market, we are inviting people to apply. So that argument is absolutely redundant here, not relevant. But their prayer in the writ petition is they are challenging the amendment of 2023. Suppose Lordship set aside that. Then 10-2 of 2018 will come into play. That also prescribes that. So now that's why I'm a little bit confused whether they want that to remain or
Which
that
they
to
have-
go,
Which they have already obtained.
which they have already obtained. Basically, why we have included that along with the written test as a recruitment test, Lordship, because every year it is very difficult to hold that examination. The last that was sometime around 2021. So far as the secondary is concerned, whereas it is not mandatory on the part of the state to have that. In respect of elementary education, Lordship, it is mandatory. At least once in a year, we have to hold it. Either, and there is also a scope of having, suppose we are skipping holding the TET or conducting the TET in a year, we can always rely upon the central TET also. The central government also conducts TET at least twice, and state also tries to do it once at least. So far as secondary is concerned, Lordship, it is always difficult. Suppose we conduct a recruitment process in 2024 and last that was of 2021. Then the interim period, 21, 22, lot of graduates come up, but they do not have the opportunity to apply for TET or appear for TET. That is why in one of the proceedings here, I made a submission before this honorable court that in all probability, we are going to remove TET from the secondary. But subsequently, this new idea came up with the government, Lordship, of which I am not privy. They have combined TET along with the recruitment test. So every time there is a recruitment test, there is a TET along with it. So that all the new incumbents, those who are new fresh graduates, they can also be a part of the recruitment process. Nobody is deprived for the vacancies which were created during the course of their eligibility. Now,
The reason for introducing this, we understand that. What about this?
law is very clear regarding
All of
NCT.
what they have argued that it's this subject regarding prescription of qualification and eligibility is solely within the domain of the NCET. That the state can't.
A state can, because the field of legislation comes from entry 25 of the concurrent list, that is list 3. List 3 very clearly says, Lordship, it is education, including technical education, medical education, and universities, subject to the provisions of entry 63, 64, 65, and 66 of list 1. Those were not directly in conflict. So we have full legislative competence to legislate in the field of education. Only law which has been settled from T.T. Srivastava case of 1999 onward, series of cases by the Supreme Court as well as by this honorable court, Lordship, that we can always have to mandatorily follow all the norms set by NCT, or in case of medical education, it is the earlier it is the MCI. In case of engineering education, it is AICTE. That way we have to follow mandatorily whatever is prescribed, and we can also upgrade, but we cannot dilute. We cannot come down. If it is 50%, we cannot make it 45%. If it is graduation, we cannot make it higher secondary. That was the case here also when we increased the medical entrance eligibility criteria from 50% to 60%, whereas the MCI said 50% in +2, Lordship. There's a huge debate going on before this honorable, and finally this honorable court upheld on the basis of the law laid down by the Supreme Court. Today, I'm little bit handicapped because I prepared 3 other cases. Those judgments I will place tomorrow if Lordship permits, because that will clinch my whole stand. It is a settled position of law. We have to mandate, we cannot, whatever prescription is there as per NCT in serial number 3, serial number 2, which my learned friend referred, we have to compulsorily maintain that. In addition, we can add additional qualification criteria. We can add additional tests also. And that is precisely when there's a challenge for TET also. When we have included it in the secondary, there were challenges. Ultimately, most of them were withdrawn cases. So there is no bar for the state to give additional eligibility criteria. Only thing is that we cannot go to the reverse way. That means we cannot negate. We cannot dilute. So that is why whether they want TET or not, that is very important, because here the issue is that they are also getting 5 additional marks also. And tomorrow, suppose we are skipping TET here.
There is a confusion regarding that 5 marks.
They should be happy.
No,
Some others will come now.
There is a confusion regarding that 5 marks also. You have to clarify this one.
I'll do that, Lordship.
That this
Page 63,
Page 63.
clause 2.
Yes.
Candidates who have passed the higher secondary so and so and not been appointed will get weightage of 5% of the
Yes.
marks secured in the respective TET. Now in TET, it is minimum 60 plus 60, 120. So 120, it would be 5% would be 6.
Will get
But-
weightage 5% of the marks secured in their respective TET, or maximum 5 marks for selection of as a graduate.
So 5% is minimum 60 plus 60. it will be 6 marks. But again, the prescription is 5 marks.
That is 5%. That means of the total.
Total 120 minimum you'll have to get. Otherwise, you'll not clear.
Lot.
It's come to 6. And here you say only maximum 5.
Five.
So this is helping them,
How can
but the
you-
others will come and raise this issue. One happy situation is that my Lord Justice Nair is not in this side. Otherwise, he would have created problem for me. But the problem is still there, but I'll try to solve it out.
Still, lawyer out, he's still a lawyer in it.
Yes, this is what is appearing.
It will take some time to get over this. A lot, this is called inertia of advocacy.
Because now we have to look at the law only, Lordship. That judgments are very to the point, Lordship. All the judgments, PTC was then subsequently in 2004 also, there's a very good judgment of the Supreme Court, followed by the 2 division bench judgments in 2008 and 9 here. I'll place everything. In fact, I argued those cases, so I am thorough. But today, Lordship, I could not, I was prepared. Tomorrow, Lordship, if it is not inconvenient. Because facts are already very much clear. Lordship,
5th of November.
5th, Lordship, too many cases were 5th, Lordship.
Sir,
Could it be on
no.
any other day, Lordship?
Then we will not be able to take up those matters because 15th is the last day. We have to.
No difficulty, Lord, on 5th. Or let it be on the previous day also, if it is not
The
inconvenient.
4th would be difficult for us.
Lordship, let it be on 5th, Lordship.
And come late in the night and 3rd. Once again,
Lordship.
go to my.
Maybe
Yes, another, you have to clarify, sir, this.
The same subject.
Secondary.
Yes, Lordship. The reason is very simple, Lordship. I want to teach, I have to get a postgraduate teacher in English. And if he is having Hindi as a subject, that will be detrimental to the students. There is no bar, but that is the area which have compelled us to.
Argument that you can't prescribe qualification other than the qualification prescribed by the
No,
NCT.
It is not that we are not saying that post-graduation is not required. Post-graduation required, but in a particular subject. That is the additional thing. That is purely from the point of view of the students. If a Hindi teacher, Hindi graduate,
You argue on this point.
I'll argue, Lord.
That, fifth, order.
Supplementary list
Deeply obliged.
for orders, item 22, along with the item 1 of production list.
My lord, basically, we have filed application seeking implement. Photo order will be doing it. Photo order to bacha na? ठीक है আমরা তিন লাখ যে দিলা হাউলি
Yeah. These are the.
My lord, basically, one IA we have filed for implement and one IA, my lord, seeking alteration of that order. All that we are praying for is, my lord, a similar line of direction as was issued by lordships in the other case.
There is a application.
That, my lord, last para, however, petitioner at liberty to move the appropriate representation
Who application?
before the authorities concerned in the state of government, seeking permission to organize lottery so and so. My lord, depending upon in some cases, it is Lakshmi Puja, it was Howli Rath. If any such application is moved, it is expected. Similar order, my lord.
Just a minute. Is this, IAs, for implement are
3308, my lord,
3308
2020.
of 24.
and
Are they out there?
3313.
3313 of 24, this idea.
24,
3311.
3311 of 24.
24.
And another file, my lord, it has been called for in the morning, Lord, my lord.
Otherwise, 33.
Address number is 3323,
3,
3323
3323.
of 2024.
3320.
These are the applications we are seeking implement, my lord.
1, 2, 3, 4, 5 applications. Okay, and
In one matter, my learned friend appears, my lord.
this 3320 is appearing.
Yes,
And these 4.
I am appearing.
And the application seeking this permission.
yes. 3330. My lord, 3309,
09.
3314.
3314, side ko diya.
14.
3312.
3312.
12.
And other number, my lord, you haven't got, it is coming, my lord.
The 33.
19.
The 3319.
Yes.
And one more application is there. Yeah. So these are the applications for implement as party respondent.
Yes.
Or we will allow them to intervene
Yes.
since it's a PIL
Yes. It has come, my lord. The other
number.
number 2. Number 2. তো ভাই পূজা এইকেইটা দিব লাগিছিল নহয় অকেজন এইটো কি লক্ষ্মী পূজাৰ কাৰণে কৰে নেকি
3325.
তৰুণ ভাঙতে কি হয়? গোটেই ৰাত এইটো এইটো কিহৰ কাৰণে এইটো বামা কাটা বামা কাটাটো কি বামা কাটাটো কালি মই এইটো ক'ব গ'লো তোমালোকে এইটো নকৰিলা এইটো কি লক্ষ্মী পূজা আৰু কোনটো খুচি My lord, that 3308, it is, the occasion is Lakshmi Puja.
These applications is this 3308 3313 3311 3322 and 3320.
Yes, here we are seeking modification of that.
These are modifications.
Yes. Seeking direction, my lord.
So, in fact, you said these are the implement applications.
No, implement are the 3308 to key asile. Yes, implement, I'm sorry, implement.
These are the implement
Yes, yes.
applications, 3309, 3314, 3312, 3319.
Yes,
And I think so 3321 hoga.
33.
Looking to this sequence by he hoga.
এখন কাগজত লিখি দিব লাগিছিল
Mr. Monto, your application, implementing.
Huh? দৌল হয়ে গেছে দৌল উৎসৱ নহয় এইটো কিহৰ অকেজনত কৰিছে মামা কথাটো কোন জাগা
For that application, last application seeking this permission or whatever.
I see,
That is not there.
No, man, I've got given the copy of the order, Miller. That was WPC 5449.
In this sequence.
Oh, last night.
Implement.
3309 and 3308. কোনটো সেভ রেখে দিই
3319.
কোড লিখা আছে আর এইটো
नया वाला
और लिखी দিব লাগে এইটো ইমপ্লিমেন্ট এইটো হেডিং পায় না
वो permission देता है। एक, दो, तीन, 4, 5, 6। नहीं, उसका इंक्लूडिंग एप्लीकेशन है 332 वेकेशन सॉरी उसका इंक्लूडिंग है 332।
The confusion
There are
is
5 applications or 6 applications?
আমার
मास आयुटा है
5 Miller
5.
4 by us and 1 by
Now there is a confusion, sir.
Mr. Chaudhary, can you just give us the number once?
yes
Once again.
my lord first
For
implement
implement only.
yes
Implement.
Implement
3308
Fine.
next to
331
3313
Fine.
তাৰপিছত
3311.
3311
3322.
332
yes 3323
And
তোমাৰ implement
3320.
20
Okay, fine. These are the implement
yes
applications. And modification applications are 3309,
yes
3314,
yes my lord
3312,
yes
3319. Yes. 3319.
আৰু এটা
And
আছে
3323,
please stay with it. Implement.
no 3325 my lord
3325. There is
Yes.
no number that 223. 3323 is not the number.
now that has come my lord 3325
Yes, that's why. only.
That is vacation. Vacation.
That is vacation.
yes
Including
3325 implementing.
no my lord vacation no
Vacation.
3325
25 is vacation.
vacation order stay vacation
heavy code, implementing code. Okay, implementing to I guess.
Vacation.
Use code.
3325 to vacation. 3223.
ৰাতিপুৱাই আহিছে
Exiting. Oh, next week. Okay. Okay.
3308/2024, 3313/2024, 3311/24, 3322/24, and 3320/24. Again number. Again, sir.
And main
These
PI
are
person,
here.
main PI.
Are preferred on behalf of the applicants with the prayer.
বাইদা কোনটো কি
Please
অকেজন
then party
এইটো
respondent.
অকেজনটো কি
Petition number 5449/2000. No. And this petition number. In PIL number 29/2024,
উৎসৱটো মাৰ্চতে হৈ গ'ল
the issue
Huh?
regarding operation of the offline lotteries illegally, regarding illegal operation of the online lotteries in the state of
2924.
Assam is raised. Stop. Then the applicants are the different organizations
6 মাৰ্চতে হ'ব লাগে নেকি
Last year or last year
who are conducting
it was a full year.
the different social organizations.
আৰু বাকী কেইটা
Basically
কি
society,
কি
To me, 2020.
societies.
Yeah, the social organization or society one and the same social organization.
Yes.
In the
Item number 18 to
religious, cultural and educational activities. Full stop. The contention is that the ban imposed by by this court by the order dated 3/10/2024 in PIL number 29/2024 on organization of the lotteries is adversely affecting their activities full stop. The applicants have therefore urged
বাকি কেইটা লক্ষ্মী পূজা
that they may be treated as party respondent in the PIL petition number 24/2000
নাম্বাৰ কেইটা মোক
so
কোৱাচোন
and so
29.
so that
গ'ল
their
এইটো গ'ল বাকি কেইটা
stand
Number
so
kita-
that their side of case
Huh?
may also be taken into consideration at the time of adjudication
লক্ষ্মী
of
পূজা
the issue raised in the PI.
আৰু এইটো
Then counsel appearing for the Mr. H.K. Das appearing as amicus curiae and the other counsels appearing for the
কিন্তু এইটো যদি
respondents
লক্ষ্মী পূজা
have
হয়
not
এইটো
seriously
পাঁচটা হ'ল
opposed
আমাৰ
the applications preferred on behalf of the applicants. Full stop. Taking into consideration.
নহয়
the
হেৰি
fact that
অৰ্ডাৰ কেইটা
the
ষ্টে
issue
ভেকেশ্যনৰ
regarding
নম্বৰ কেইটা
operation of the organization of the offline,
এইটো কি
online illegal lotteries in the state of
আৰু এইকেইটা
Assam
ইয়াৰে কোনটো ষ্টে
is
ভেকেশ্যন এইটো নহয় এইটো
is to be decided in this PIL. The stance of the various stakeholders is also liable to be taken into consideration. Hence, in the interest of justice, we permit the applicants to intervene in the writ petition in the PIL petition number 29/24. With these observations, these IAs are disposed of. Now, this application number is 3309 24 3314 3312 3319 3325. Full stop. These applications are filed on behalf of the applicants seeking vacation/modification of the order dated 3/10/2024 passed by this court in PIL number 29/2024. It is the case of the applicants that they are the social organizations organizing various cultural and social activities for the benefit of public at large. Full stop. It is contended that in the ongoing Ras festival, with a view to encourage the large participation of the public of the public, they are organized, they are organizing
Lord, your lordship.
কৰ্ম কৰি লাষ্টত কৈ চবতে ৰাখ নহয়
organizing lottery
Plus,
/ lucky coupon. Yeah.
I'm sorry, my lord. Lordship, in all, not Ras festival, the festival. the
I'll
occasions
clarify
are-
that, I'll
number
give
one.
the number.
Number one, my lord, the occasions are different, that is one thing. And if your lordship is contemplating to pass a similar order, likewise, the one has been passed in WBC 544/2009/2024. But I have got some reservations with that.
Why?
Lordship has passed an order that they can move an application to the government seeking permission. If we go by the law, 1998 Act and the regulation, as well as the rules of the state government, there is no scope for moving an application.
Even though they move and representation, what we have ultimately observed,
Go by the rule and the regulation.
My lord,
it is expected they will consider and decide the same expeditiously, taking the provisions of so and so, so and so.
So this honorable court is, my lord, entrusting a responsibility upon the state government.
But even though in many cases, there is no such provision of moving representation and all, and while exercising jurisdiction.
I think
always give a direction
there
considered.
is a fallacy in my learned friend's contention, my lord. There is no concept of prohibition. There's a concept of only regulation.
My lord, for
State
that,
will regulate.
no, for that submission of
we'll
my.
consider, sir. But only this is.
Yes.
Simply we are allowing them, okay, if you want, suppose if they don't want to have this lottery or something, or as some other method which they want to permission.
Why I am saying so, Milord, the basis for my submission is that page number 111, local 15, local act. Why I am making this submission, Milord? Any other organization except the state government is not authorized or
You're
they
right,
cannot.
absolutely right.
If they cannot, how can they seek permission or how can?
Even though for the purpose of organizing other activities also, they're required to take permission from the
Exactly.
government.
That they can do, but so far as lottery is concerned.
Along with that, if they move an application, then the state government will consider the same.
Yes.
Strictly in accordance with law, and if the state government grants permission in a contravention of that, you may point it out.
Yes.
Consider it. It's always open for you to point it out that though the direction of this court is to consider their representation in the light of this, and they have granted this permission contrary to that, we'll consider it.
That's true, but your lordships, this exercise, perhaps.
Mr. Das, ultimately, yes, you are right, that these order we have passed, but if they are organizing these such type of activities seems
Once a year.
once a year seems long, let them take a chance with the state government. See to it. We are concerned about your concern is valid, but at the same time, some yes, Kelly.
I appear for respondent number 66 and similarly placed my learned seniors line. So my lord is contemplating to pass that order, that would also be applicable.
Move an application, then only will pass an order, otherwise no. It would be very difficult for us. Move specific application will grant you permission to move representation, not in this manner. Openly, it would be very difficult and it will, it may give a license to the state government to issue licenses and nothing. Yes,
Already a party is.
move an application will grant them. Yes. Now ongoing festivals kar dete hain, not Ras festivals.
My lord, I'll give the number and the occasion, my lord. My lord, item 3312 and 3325
Ras,
Ras.
okay.
Ras. Then my lord, 3314 Lakshmi Puja.
Lakshmi.
Lakshmi Puja, my lord. Yes.
3314 and 3312.
Yes, my lord.
Yeah.
Rach.
Lakshmi Puja.
3314 is Lakshmi Puja. 3312 and 3325 Rach.
3325. Sorry.
And my lord, 33.
Just Lakshmi Puja in 3314.
Yes, my lord.
Yes.
And my lord, 3309 Dol. Dol Utsav.
Yes, and your Lakshmi Puja 331. क्या लिखा है? Organizing lottery slash lucky coupon draws at Ras festival, Lakshmi Puja and Dol Puja. Dol Puja.
Dol Utsav.
Dol Utsav. Stop. It is contended that in view of the order passed by this court, they are apprehending that the state government shall not grant them permission to organize lottery slash lucky coupon draw in the above referred festivals. It is therefore prayed that the impugned order may kindly be either vacated or modified and allow the applicants to organize lottery slash lucky coupon draw at the above referred festivals as festivals, the practice which is going on since eons. Full stop. Having heard the learned counsel for the parties and after going through the applications, we are of the view that the order passed by this court dated 3/10/2024 in PIL number 29/2024 is not liable to be not entitled to be modified or vacated. However, the the applicants are at liberty to move appropriate representation before the authorities concerned of the state government seeking permission to organize lottery/lucky coupon draw on the eve of the above referred festivals. Full stop. If any such application is moved by the petitioner, by the applicants, it is expected that the state government will consider and decide the same expeditiously, taking into consideration the provisions of the lotteries in bracket regulation bracket close act 1998 and the lotteries in bracket regulation bracket close rules 2010.
Deeply obliged.
With these observations, these IA number so and so are disposed of.
Also file an application.
Tomorrow you will not get it. It's too late.
Alina Thoma.